Welcome, and thank you for taking time for your own learning today about the rights of children with developmental delays or disabilities. This training video provides information about services for children getting ready to transition from early intervention services at age 3. Included is information to help families support their children in preschool and into primary school. Part 1 of this series, also available on Pave's website, includes information about birth to 3 early support services. Let's get into the important content of this training, which focuses on the rights of children ages 3 and older with disability conditions that impact educational access. We'll start with the transition into preschool for children who received early support services and how to seek an educational evaluation for a child who didn't have services as an infant or toddler. We'll look at IEP development and key questions for family advocates. Please note that no federal or state agency has waived any of the protections for children with disabilities due to the circumstances of COVID-19. Many services have shifted to be offered in different ways during the pandemic, but no disability or educational rights have been waived or changed. Pave provides a variety of resources to support basic understanding about a child's rights when making the transition from birth to 3 to early support services. From our website, which is wapave.org, you can type Early Learning Toolkit into the search bar for an article that includes links to the resources listed on this slide. When a child with an Individualized Family Service Plan, the IFSP, is about 2.5 years old, the Family Resources Coordinator, the FRC, initiates a planning process that includes an evaluation to determine whether the child is eligible for an Individualized Education Program. That's the IEP at preschool after they celebrate their 3rd birthday. The transition from early support services into school-based services includes some key requirements listed here. 1, the family is involved. 2, the child is prepared to adjust and function in a new setting. 3, the least restrictive environment, called LRE, is considered for IEP services. 4, information is shared with parent consent to ensure continuity of services. And 5, the IFSP team collaborates to ensure a smooth transition into whatever's coming next. IFSP transition includes an evaluation to see if the child will have an IEP at school. The next several slides provide an overview of that process, which is the same for a child of any age who is being considered for special education services. The federal law that governs the special education process is the Individuals with Disabilities Education Act, IDEA. Part B of the IDEA governs the IEP process and the delivery of school-based services. IDEA requires that educational evaluations be comprehensive and varied. They must include data collected in a variety of settings in all areas of suspected disability. Ultimately, the data collected is used to consider these 3 questions. Number 1, does the student have a disability? Number 2, does the disability condition adversely impact access to education? And 3, does the student need specially designed instruction? Sometimes that's called SDI. and or related services. Related services include therapies delivered by trained professionals, such as occupational therapy, physical therapy, speech, counseling. If all three answers are yes, then the student is eligible for an IEP. These are the broad eligibility categories. Notice the last one on the list, developmental delay. Developmental delay is used to determine eligibility for birth to 3 services, but also could be used to qualify a student for IEP services. In Washington, this category may be used on the IEP through age 9. At that time, an evaluation would need to determine eligibility in another category for the student to continue receiving special education services. Keep in mind that these categories support a student to get help and were never built to label or stigmatize children. Family advocates should be prepared to call out anyone who inappropriately uses these categories. For example, there is no such thing as a behavior IEP or a behavior kid. It's also important that an evaluation consider all areas of potential need. Sometimes the student is acting out because of an underlying learning disability, for example. The evaluation should be comprehensive and varied to make sure every issue of concern is considered and captured in the data. If a child is super frustrated and acting out doing pre-reading skills, for example, the frustration and the pre-academic skills need to be assessed. An evaluation can determine if there is a learning disability, a processing disorder, an emotional regulation delay, or something else. In that case, the child may need specially designed instruction in reading, emotional regulation support, and accommodations such as speech to text to keep them happily engaged with grade level books alongside their peers. These categories are used to determine eligibility for services. Once a child is eligible, an IEP team is responsible to design the services and the placement to meet the needs of the whole child. A new evaluation is not necessary to justify every service. That's up to the team to decide. Families looking at an IEP document for the first time are understandably overwhelmed. Depending on the child's needs and the complexity of the program, the paperwork can be quite hefty. Pave provides an article with steps to read, understand, and develop an initial IEP. The article is also helpful for families further along in their IEP journey if they're struggling to understand how and what to look at on all those pages. I recommend that families start by looking for the service matrix. It's a chart that is usually about halfway through or near the end of the IEP. This is where a student's services are listed in a grid. The chart includes the who, the where, and the when of services. Notice if a special education teacher, a paraeducator, or someone else is responsible to deliver the service. Prepare any questions to discuss with the IEP team when you meet. Does the amount of time, for example, that is provided make sense for the goals that the child is working on? Now for the where part of the service matrix. If a child is going to be served in a special education classroom, then it says that. Those are pull-out services. If services are provided in the child's regular general education classroom, it says that. Those are push-in services. Notice the list on this slide includes a bullet for LRE statement/placement. LRE stands for Least Restrictive Environment. That requirement comes from the federal law, the IDEA. Schools are required to support students in general education to the maximum extent appropriate to meet their needs. Their needs, not the programming needs or the convenience needs of the school. Usually, a page or two behind the service matrix is the LRE statement page. That's where the IEP says how much time the student is spending in specialty spaces versus the regular classroom. Parents have a right to disagree with the LRE statement and to discuss with the IEP team how their child might be supported for inclusion in general education. This might be an important topic for families when their preschoolers move into kindergarten. Children have the right to education in the least restrictive environment to the maximum extent appropriate in preschool, primary school, and beyond. The longest section of an IEP is the present levels of performance, or PLOP, which includes information from the evaluation. This data is used to create annual goals for the student. Remember that the specially designed instruction, SDI, and the related services are designed to help the student reach those goals. It's not all up to the kids. Usually near the end of the IEP document is a list of accommodations and modifications. Those are supports that enable equitable access to learning for a student with a disability. It's important that these accommodations be individualized and that the school, family, and student know what they say and how to advocate for them. Here's a sample empty grid for developing the IEP service matrix. You can see that the when, who, and where are required. This model form is provided by Washington's Office of Superintendent of Public Instruction, OSPI, which is the state agency that provides guidance to the state's local school districts. There's a note to the side of the sample grid explaining that if the school staff responsible for a service is not a certificated special education teacher or a related service provider, then a professional at that level is required to supervise and monitor how the service is delivered and the student's progress. A separate section of the service matrix is used for related services. More about that on the next slide. Occupational therapy, physical therapy, speech, and nursing are typical related services. Note that a related service also might be orientation and mobility for a blind student, applied behavioral analysis, ABA, or counseling might be necessary for a student with behavioral health needs. Also, training for staff can be a related service, and parents can get training to support the learning of their students. IEP teams make the decisions about what is necessary for the student to receive their free, appropriate public education, FAPE. Note also that an IEP can provide related services to a student for free through the public school, even if the child receives most of their education elsewhere, such as through a homeschool or private school. On the slide that listed the parts of an IEP, I mentioned the PLOP, the present levels of performance. It's important to know what the IEP says about a student's present levels to know what the services are supposed to help with. The goals show where they're working. On the slide that listed the parts of an IEP, I mentioned the PLOP, present levels of performance. It's important to know what the IEP says about a student's present levels to know what the services are supposed to help with. The goals show whether they're working. It's up to the IEP team to make sure the goals are SMART, and that stands for specifically written with a practical way to measure progress, and the goals should be attainable within a year, but not too easy. And the learned knowledge or skill should be relevant to the child's life. Timeliness means that the student will hit the goal by the targeted date in order to move on to another level of learning. Parents have a right to high expectations. Too easy goals and trivial progress do not meet the standard for a free, appropriate public education, FAPE. A few slides ago, we looked at the service matrix from OSPI's model form. This is the sample table for accommodations and modifications. An accommodation is something that helps a student, such as an assistive technology or more time to finish something. A modification is a change in the expectation, like a shorter assignment. Please note where the form lists other. Individualized supports are appropriate. On the next slide is a sample list of individualized accommodations and modifications. Keep in mind that options are endless and IEP teams are called on to do creative problem solving. Here are a few examples of individualized accommodations and modifications. Keep in mind this list is endless. Daily check-in, check-out with a champion. A champion is a trusted person who is there to uplift the student and never does the discipline. Headphones and preferential seating in a quiet area when reading with text-to-speech. This accommodation could be a game changer for a student with a reading disability. Student choice for seating, a wiggly chair, chair with a band, ball chair. A child with sensory needs may need a uniquely designed list of options. Weighted blanket or a stuffy upon student request. Specific comfort measures are reasonable and common accommodations. Snacks from home available during morning and afternoon recess. Remember that the family isn't asking for special favors, but to have their child's needs met. Do not call on student to respond orally during group instruction. Think of a child who is painfully shy or may have selective mutism. Show understanding of science concepts through visuals or art. This would be a modification for a student who learns and communicates differently. Shortened math assignments, for example, the odd-numbered problems. This may be a modification for a student with reduced stamina or attention struggles. Student can place yellow card on desk to leave class. A child who needs to take a break might be intimidated to ask out loud, so this individualized accommodation could be key. Access to zones of regulation corner at all times. The IEP team sometimes needs to take a child's perspective and make sure they will be able to self-advocate for their needs to be met. The last example says toileting help follows nursing plan. This is a way to customize a complicated process so that it's included in the accommodation, but then the nursing plan itself is a separate, longer document. If you looked at part 1 of this training series, you've seen this pyramid of student rights before. This is a good time to take another look because accommodations are protected in the middle of the pyramid by the civil rights laws that include Section 504 of the Rehabilitation Act. Remember that the key to upholding these rights is equity. Are the supports enabling the student to have equitable access to an opportunity that everyone has access to? Remember also that a student with an IEP has rights all the way down this pyramid. The next slide helps family advocates use this information to participate in their child's education. Using what we've learned so far about student rights, let's look at key questions parents can ask. The first two questions apply to an IEP or a Section 504 plan. Both include accommodations and modifications for learning in general education. The final question applies to the IEP, which includes goal setting and progress monitoring. So number one, is the learning accessible? Number two, are the learning opportunities equitable? And number three, is the IEP designed to enable progress appropriate in light of the student's circumstances? That word appropriate comes straight out of FAPE, the right to a free, appropriate public education that is uniquely designed, in other words, individualized. Here's a reminder that the IEP is provided following Part B of the Federal Individuals with Disabilities Education Act, IDEA. Listed on this slide are 6 general themes from the IDEA. The first is FAPE, free, appropriate public education, and the rest all have to do with FAPE. So a student eligible for special education services is entitled to an appropriate, non-discriminatory evaluation, an IEP that provides FAPE, and education in the least restrictive environment to the maximum extent appropriate. General education classrooms are the least restrictive settings, and schools are required to demonstrate why a student is unable to access FAPE in the regular classroom before recommending a more restrictive placement, such as a structured learning classroom. Under the IDEA's 5th principle, parents and students have the right to participate in educational decision-making, and schools are responsible to encourage and accommodate that participation. Of course, that includes language access. The 6th principle provides families the right to request mediation or to file a complaint if they believe the school district violated procedural safeguards. I hope families feel empowered to start using this vocabulary because it shows that you understand your child's rights. When the United States Congress passed the IDEA in 1990, lawmakers used the word FAPE to describe what a special education student is entitled to, an education that is uniquely designed and appropriate. Virtually every conversation about student services is about FAPE. Is the student getting what is necessary and appropriate? How FAPE is described and defined has changed over the years. In 2017, the Supreme Court heard a case about a child named Andrew, whose parents said the school didn't provide FAPE. In that case, the Supreme Court ruled that the school failed to provide FAPE because Drew's IEP did not include enough services to enable appropriate progress toward his educational goals. The ruling included firm language to reinforce progress toward grade level standards and parent participation in the IEP process. The court's wording included the key phrases highlighted in purple on this slide: to meet the standard of FAPE, which is referred to in the ruling as the school district's substantive obligation. A school must offer a child an IEP reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances. Here are a few general points about the IDEA and IEP that put those 6 principles into practice. First, special education services are built and delivered based on the needs of the student, not to fit within a program that already exists. Second, special education is a service, not a place. An evaluation is never conducted to figure out where a student will learn. Data is used to help an IEP team make decisions about what help is needed. Where a student learns is called the placement, and that gets decided after an IEP team has determined what services are necessary. This may be especially important for parents of primary school students coming from special education preschools. The right to LRE is intact, and IEP teams are responsible to discuss what supports a student needs to be included with typically developing students throughout the school day. Thirdly, education is broader than just academics, and services are designed to provide equitable access to all aspects of learning in school. That might mean academics. It might mean special classes like PE and music. It could mean extracurricular activities. And it might mean social and emotional learning for appropriate access to recess and lunch and friends. Here's some language straight from the federal law, the IDEA, to reinforce understanding about the requirements for education in the least restrictive environment, LRE. Schools must ensure that, 1, to the maximum extent appropriate, children with disabilities, including children in public or private institutions or other care facilities, are educated with children who are non-disabled. Note that that includes preschool. 2, special classes, separate schooling, or other removal of children with disabilities from the regular educational environment occurs only if the nature or severity of the disability is such that education in regular classes with the use of supplementary aids and services cannot be achieved satisfactorily. Here is the Washington Administrative Code. We call them the WACs, that provides information about the rights of parents to participate in their child's special education decision-making process. It's easy to find this information. From your browser, type WAC, W-A-C, parent participation in IEP to find and access this link. Some families face barriers related to language access. Under state and federal law, families have the right to information about their students' education in a language they can understand. And students have a right to accessible learning materials. Washington's Educational Guidance Agency is the Office of Superintendent of Public Instruction, OSPI. OSPI provides guidance about language access rights, and that guidance is provided in multiple languages. Pave provides a variety of tools to help families in this journey. The form pictured on this slide provides a way to build a handout for a meeting with the school. If you type toolkit into the search bar at wapave.org, you will find our Toolkit Basics article with access to this link and a lot of other information included in this video. Parents have a right to dispute decisions made by their schools. Those rights are protected as part of the procedural safeguards. OSPI provides a link to a copy of the state's procedural safeguards document, which is provided by the school upon request and offered anytime there is a formal meeting. I recommend you read them. And our PTI team at Pave is always happy to help you understand your procedural safeguards. There are other agencies that can also help. I call these the 3 O's: OSPI, the Office for Civil Rights, and the Governor's Office of the Educational Ombuds, which provides online and one-to-one support for families who are struggling to collaborate with their schools. Here's a screenshot of our website. It's pretty easy to find articles on the topic you're looking for by typing a keyword or two into the search bar. You can also scan through articles and resources by clicking Learning in School. If you type the keyword Toolkit Basics into the search bar, you'll find a link to an article with key basic information about student rights and IEP development. For individualized assistance, click Get Help from the toolbar in the upper right-hand corner of our homepage. Here's our contact information. We provide individualized assistance if you reach out by clicking Get Help, or if you call and leave a message at 800-572-7368. We have language interpretation services. You can also find us on various social media platforms, including Facebook. Pave is not a legal service organization and can't give you legal advice or represent you. Our PTI program funding comes from a U.S. Department of Education grant, but the U.S. government doesn't review our training materials in order to endorse them. We'd love to know whether this video was helpful for you. On the page where you found this video, there's a link to a short survey. Thank you for sharing your feedback. Thank you for listening and learning. And please do contact us at wapave.org for individualized assistance or further training opportunities.